You to the program. I hope I got your name right.
You did. Thank you.
All right. Thank you for being here today. All right. Prosecutorial discretion in the context of immigration. I know you've been speaking about this, and you actually spoke about this week, and I'd like to, first of all, get a sense of what prosecutorial discretion is.
Sure. So prosecutorial discretion in immigration law refers to a choice or decision that the immigration agency, in this case Department of Homeland Security, makes about whether to enforce the immigration law against a person or a group of persons. So much like a prosecutor in the criminal context, when an immigration officer chooses not to bring legally valid charges against the person because of her family ties in the United States or other equities, then we might say that prosecutorial discretion is being exercised favorably. So this is sort of a non-enforcement form.
Okay, so this is not prosecutorial discretion being exercised by the president, but rather his giving the ability to exercise that discretion at the more local level?
Correct. In fact, several of the documents that were issued as part of the November 20th action were in fact policy memoranda on Department of Homeland Security letterhead that will then be delegated to officers throughout the department.
All right. So let's get into specifics now. What does this mean in terms of what specifically the president authorized on November the 20th last year?
So some of the key pieces that relate to discretion that were authorized on November 20th, one is called Deferred Action for Parental Accountability, or DAPA. This is the program that's received the most amount of attention, and it would enable certain undocumented parents to request deferred action and work authorization if they can show continuous residence since January 2010 and a qualifying relationship as a parent to a child who is a U.S. citizen or a green card holder. Importantly, the DAPA program prohibits people who are an enforcement priority for removal from applying or benefiting from the program. So what would it do? It would actually defer the deportation for a period of 3 years for certain parents and provide what I sometimes call immigration purgatory, because there are certainly limits to deferred action and other forms of prosecutorial discretion. This is not a formal legal status. It does not lead to an independent path to a green card or citizenship. Instead, it is a tenuous period of lawful presence that in some cases will also authorize the person to work.
Okay, there's another, I guess, policy change in this too, right? The expansion of the deferred action for childhood arrivals. That's the DACA. That's the other part, right?
So a second program, because there were actually several actions that were packaged on November 20th, does tweak the DACA Deferred Action for Childhood Arrivals program. This is a deferred action program aimed at children who entered the United States before the age of 16, who are in school and meet other requirements. And what the president did was manicure some of those requirements by lifting the age cap and bumping up the residency period so that a few additional people would qualify. So this sort of adds to an existing program that was created back in 2012.
All right. Shava Wadia is with us, Samuel Weiss faculty scholar at Penn State University, as we're discussing prosecutorial discretion in the immigration law and specifically focused on President Obama. Now, given what you've given us as the sort of foundation here, let's talk about the president and his authority to do this, and I guess specifically with immigration law. I wonder how different this is, because people often harken back to things that either President George H.W. Bush did or President Bush or maybe even Ronald Reagan. Now, Homeland Security didn't exist then, so does that at all change the dynamic? It did exist under President George W. Bush, but does that at all change the way that you look at the law from the standpoint of whether or not the president has the authority to make certain exceptions to the enforcement of the law?
Not really. Prosecutorial discretion's been part of the immigration system for as long as the system has operated, and both under the former agency, Immigration and Naturalization Service, and in the Department of Homeland Security that was effective on March 1st, 2003, we see prosecutorial discretion being used boldly both towards individuals and groups. Much of the law stems from the Constitution as well as the immigration statute or code, which specifically delegates to the Department of Homeland Security the authority to make decisions about immigration enforcement. And Congress is the author of the immigration code and gave this responsibility to the Department of Homeland Security.
Okay.
This is authority that has also been affirmed by the U.S. Supreme Court in several decisions. More recently, in the Arizona decision from a couple of years ago, the court said that a principal feature of the removal system is the broad discretion exercised by immigration officials. As an initial matter, they must decide whether it makes sense to pursue removal at all. End quote.
So, based on that, then the president's action in November of last year could be undone either by legislative action by Congress, assuming it got through and was veto-proof, because obviously the president would not sign a bill that would usurp his own executive action. It could be undone by that, or it could be undone by a subsequent presidential executive action by either this president or another president, correct?
Conceivably, yes.
Okay, so is there a way to look at this from the standpoint of what the case is before the courts now? Because I know that you said that the most recent one, the Arizona case, is one that that resulted in an upholding of the executive authority, but there are still challenges to that, correct?
Yeah, there have been challenges that, in my view, are predictable and political, largely similar to the legal landscape we saw following the creation of DACA. And, you know, I would say that in most cases there may be an issue of standing, and in particular with the case that was thrown out against the sheriff of Maricopa County and the decision by a Pennsylvania judge pontificating on prosecutorial discretion in an individual decision. These were highly political as opposed to raising a genuine legal question. For me and for more than 120 law professors who signed a letter affirming the legal authority for the president to exercise prosecutorial discretion in the way that he announced on November 20th, the Constitution, the statute, the regulations make that authority pretty clear.
Can you address the criticism that an existing executive action by changing the discretion, and you mentioned the purgatory that people find themselves in, but the criticism is it becomes de facto the law because you can't reverse what takes place in some cases, and in the particular cases of how the discretion is exercised in immigration law.
So the de facto nature of prosecutorial discretion, that is, again, not something particularly new. And the differences between actual legislation that would confer permanent legal status is significant in contrast to a grant of prosecutorial discretion, which, as you suggested, could conceivably be taken away at any time. Just if we were to compare DACA, which is familiar to many, and the DREAM Act, right? These look similar on its face, but these are very different because one leads to a grounded status that could eventually lead to U.S. citizenship, and we just don't have those kinds of benefits associated with grants of prosecutorial discretion. You know, it's also important to just look at the landscape here. There are some real economic and humanitarian reasons for why we have prosecutorial discretion in the first place. There are over 11 million people, by some estimates, who are residing in the United States without authorization. And Congress has appropriated funds for removing 400,000, or less than 4% of the entire removable population. So the agency has to make choices about who to target for removal. And so by creating programs like DACA, extending DACA, and then delineating its priorities for removal, which is another important piece of the November 20th plan, the administration was simply showing the world, really, about how it was going to manage resources that are limited, and also focus on the humanitarian equities for people who, frankly, shouldn't be the highest priority. Again, these themes have been recurring in immigration for many years.
I just have one more question before we run out of time, and I appreciate your time, and that is, does the federal government trump local on this particular case? In other words, if there is discretion, if local authorities choose to exercise that discretion in a different way, is this a shall or a may situation, and who trumps whom in this case?
So the federal government is responsible for setting policy on prosecutorial discretion, and line officers who are asked to implement a program that is targeting a group or an individual are following guidance of the agency head. So it is a federal policy.
But if local police, for example, decided to exercise authority in a different way, would that run them afoul of this executive order?
Possibly, yes.
Okay. It's not quite clear, it sounds like, then, that it's not cut and dry.
It's cut and dry that the prosecutorial discretion policy is a federal policy, and that authority rests with the federal government.
All right. We'll leave it at that. Shobha Wadia, thank you for being with us on POTUS today.
My pleasure. Thank you for having me.
Shobha Wadia is Samuel Weiss Faculty Scholar, Clinical Professor of Law, and Director of the Center for Immigrant Rights at Penn State University. And the Twitter handle, I'll spell it for you, at SHOBAWADIHIA.